Alex here with part 5 of the My Docket series on child custody and visitation. As with all of my previous videos, please stop this video and watch part 0 if you haven't seen it yet. It contains all of the boilerplate for this entire series. It's going to be a very long series, and I'm not going to go into all my disclaimers in each and every single video because that would be really inefficient for the people who have been watching it for a long time. Also, I will at least glaze over the 2 big disclaimers for people who are going to skip that video, which many people invariably will. The first is, do not feel sorry for me, do not feel bad for me. I am not looking for support or allies. I have already terminated my ex's parental rights. My case is over, it's completely closed, it can't be reopened, it's done. And the second is that this video is for educational purposes. One of the biggest things that I've heard from my viewers is examples help a lot. And so one of my responses to this constant feedback that I'm getting is to create one gigantic example, which is the entirety of the My Docket series. So that being said, let's look back to part 4, which is where I responded to the temporary order for protection that my ex received that she filed against me by filing in part 4 an ex parte motion to dissolve that order of protection. I wasn't quite finished with my reaction there, and I can remember why. My mindset at the time of having been given the temporary order for protection by a sheriff's deputy was to freak out, and this is because I thought I knew my ex. I never imagined in my wildest dreams that she would suddenly claim I was a dangerous person and that I was trying to kill her and that I was going to go after her and stuff like that. And so I reacted initially by trying to dissolve that temporary temporary order of protection. It's not a temporary restraining order, that's different. It may be considered a type of TRO, but it's actually, the formal name for it in Nevada is order for protection. My initial reaction was to try to dissolve that. My second reaction a day later was to go back to the initial case that I opened, which is the child custody and visitation action, and file 2 more motions in that case. And those 2 motions could have really been done as a single motion, but because I didn't understand that I could type up my own motions and I thought I had to use the packets that were online or for the packets from the self-help center, because I thought I had to use those, I didn't understand this, and so I filed 2 separate motions, and in each motion I put an issue. And so ordinarily going forward, I'm going to do one video. I mean, each video will cover 1 motion, but in this case, because they're both really short and they could have been just converted or merged into just a single motion, I'm going to go ahead and cover both of those motions in this video. There's also 3 different housekeeping papers that were filed, which I'll lump into this video as well. 2 of them are requests for submissions. If you don't know what those are, watch my video on requests for submissions. Many states and even counties in Nevada don't use them. It's actually something that we only use in one of our counties, at least as far as I know. And the other one is a summons. Apparently the summons was filed. In part 1, I assumed that they didn't file it, and so I covered a blank form as to what a summons looks like, just to help my viewers out. But I did find out later on that the summons was filed, and it's probably because of me being a self-represented person. I didn't know I had to file it, and I probably just didn't know and found out way later and went and filed it. Like, it looks to me like I filed it 3 weeks later, but I'll look at the date when I actually get to the document, and then I can get more specific on that. So we'll be going over that too. But these are very simple, like I mentioned, housekeeping papers that don't really deserve their own video. It would be a very boring video because there's nothing really in them, and there's no substance to them really, except for me to explain what it is and what it does, and that's it. So I want to really stress that my reaction here, while ordinary, is pointless. The filing of both of these motions is completely pointless. Number 1, it shouldn't have been done ex parte. Number 2, it's not an emergency. And number 3, what I'm asking for isn't really something that I'm entitled to relief on under the law. This is one of the examples as to what a self-represented person will do when they don't understand how the law works, when they think it's just a judge wearing robes who has opinions and 2 people who walk in and make reasonable requests, and the judge decides if that sounds good and grants the request or not. there has to be some kind of legal basis for what you're asking for. And the requests that I'm making in these either are not based on anything, there's no legal basis for either of these requests. And also, the other thing is, with one of my requests, it is reasonable, but the way I'm going about getting it is wrong. And I'll go into that when I actually get to the page. I wanted to stress, and I know I kind of talked about it a little bit earlier, that it's normal to panic and freak out when your ex does something that you didn't expect. And I think that is because so many of us, we have been with our partner for so many years, and we think we know them. And we don't really mentally prepare ourselves for what's to come. And so when something alarming happens, it's normal to freak out and panic. And once you realize that your ex is doing things that you never thought they would have done, it's a very short step to the conclusion that you don't have a clue who they are. And it's a very short step from there to the conclusion that they could do all kinds of crazy things. If I don't know who they are, then there is no limit to what I can expect. And I really also want to emphasize before I get into the documents that in my part 1, there isn't really a long list of allegations, accusations, and attacks from me in the petition to establish child custody and visitation. And I mentioned that. I mean, at that point, I was just a normal person going to court, filing a piece of paper to get rights to see my child. And so I wasn't thinking, I need to accuse my ex of all sorts of crazy things. And now, having seen the order of protection that she was seeking against me and the allegations that I'm dangerous and I'm violent and I'm going to hurt her, having seen those, I have now, I'm freaking out. So now, I mean, as with my previous motion, which was the one to dissolve the order of protection, in these two motions, again, I'm emphasizing all of the things that are alarming to me. The police reports, the attempted suicide, the claims that she isn't a good parent. These things all of a sudden are leaping out at me, and I am feeling that urge to let the court know all of these details because my ex is now starting to act crazy in my eyes. Like I can remember that the shock and the jolt from having that specific reaction from her in a court paper was so unnerving and disillusioning for me that I completely just had no clue what to expect from her. And that's kind of the product of these two papers, which I'm going to go over now. So let's take a look. So here we have the ex parte emergency motion that I filed with the objective of prohibiting my ex from removing our son from the state. First thing I wanted to mention is, and I talked about this in several of my previous videos, I'm not a huge fan of ex parte anything, and this specific motion, in my opinion, should not have been done ex parte. It certainly isn't an emergency. I don't have any allegations or any threats from my ex that she is threatening to take the child and run. Also, it shouldn't have been done ex parte. Maybe if I had some kind of background where she had like abducted children in the past, maybe with another boyfriend, or maybe to me, I could have potentially argued that if I file this and give her notice of what I'm trying to do, she may respond by deciding, oh, I'm going to run and flee the state before the court gets a chance to make a decision to sort of evade the whole contempt of court thing. But I don't have anything like that on her in the past. She's never done anything like that. This is just my emotional reaction. This is my freaking out to the fact that I don't know really who she is. And since I don't know who she is, she's capable of anything, including fleeing with the child. And I want to go into another couple of things here. This idea of filing a motion to prohibit your ex from leaving the state is kind of a non-starter to begin with. And the reason why is there are already laws that forbid a parent from abducting a child. I think they call it custodial child abduction or something like that. Some states will still call it kidnapping, but most of them have a different label for it. And so the way the judges feel is they don't need to enter an order telling the parent to not flee with the child. Whether you're thinking that they need to stay in the city, that they need to stay in the state, or that they need to stay in the country isn't really relevant to any of the judges. And this is ex parte emergency aside. I'm talking about if you just filed an ordinary motion that wasn't an emergency. I really still feel that there is no basis for any of this stuff, and that's mainly in line with what the judges think, because they think, and this does happen to be true, if a parent does abduct the child, they have violated the law anyway. They have committed a crime anyway. And so a civil judge who's presiding over a family matter doesn't need to go above and beyond and create an order that they now have to abide by, because there are crimes that they would be committing by doing it anyway. The other thing I wanted to mention is that it is my understanding that you can't keep your ex inside of a particular city or county or state. You just can't. As long as they are exercising their custodial time in a way that is within the boundaries that the court has provided, they are allowed to do what they want during that custody time. If they have 3 days of custody time and they want to go to Disneyland and come back and it's in another city or in another state, they can do that. That's their custody time. If they have decided to exercise a holiday visit or exercise vacation time and spend a couple of weeks in Texas, even though you live maybe in Maine, they can do that. It's their time. If they want to use their time in another state, they can. There are often concerns with regards to communication, like letting another parent know where you're going, or letting another parent know like how long you're going to be gone and where you can be reached at by what number, stuff like that, how you're going to facilitate telephone visitation, if that's a thing. Letting a parent know about those things is separate. You can't really conflate these ideas. You can't really say, hey, since I can't guarantee that you're going to tell me where you're going, and I can't guarantee that you're going to allow me telephone contact, I don't want you to leave the state. You can't mix those two things together. If you have a problem with not getting contact or not being told where the child is going, then that's a separate issue that can be brought to the court. And the court will look at that in and of itself and render decisions on that, whether it's going to be a custody decision or a contempt issue or something else. But the court won't say, oh, well, that's understandable. Since you're concerned about not knowing where they're going, I'm going to go way beyond that and say, you're just not allowed to leave the state. You're just stuck here. They don't do that. Leaving the country is a little bit more complicated, because there are often arguments that come into play with regards to dangerous countries and stuff like that. I won't go into that in this video. I have other videos that cover that topic. But I just wanted to say that this paper is an emotional reaction. I would definitely not have filed it had I had the experience now. Sorry, had I had the experience then that I have now. And it does ultimately get denied. I think it gets denied because I filed it as an ex parte motion. But even if I didn't file it as an ex parte motion, I think it would have been denied anyway. So this is something that I shouldn't have filed. But I'm still going to go through it because, as I mentioned to my viewers, I want my viewers to know that I didn't know what I was doing the whole time. And that this is an example of something that I filed that is ultimately denied. So let's take a look at it really quickly now. Code number in the top left, I've talked about this in my previous videos. It's only in one of the counties in Nevada, 2nd Judicial District Court uses these code numbers, but no other courts in our state do. I think 8th Judicial District Court uses another scheme. It's not a number scheme. It involves letters and stuff like that. It might be alphanumeric for all I know. Let's see here. You can see that the case number and department number are filled out now. In part 1 of this case, they were blank, and that is because the action hadn't been instituted yet. So my reasonings, I don't want to glaze over these. Let's take a look here. Requesting the court order my ex to not leave the state with child. This is wrong, because here I'm stating that a decree of divorce or order addressing custody was entered, but at this point in time, no orders were entered. And this is one of the problems with using self-help forms. When you get a self-help form, you're thinking, how do I follow the instructions that I need to get the result that I want? And so you'll get to these blanks and you'll be like, wait a minute, no decree was entered, so I have to put something here. So I have to put some kind of date. So this September 5th date, it makes me wonder what I'm referring to. I'll take a look at it later when I get a chance, and I might post something down in the comments below if it's relevant. But I'm probably referring to some other paper or pleading that was filed in the case, because at the time of this filing, there was no order yet. Oh, okay, here it is. I'm referring to the temporary protective order. So I didn't know what to do because I don't know anything about the law and I'm brand new at all this. So I just assumed that since only one order has been entered, I'm going to refer to it. But this is wrong because this order wasn't even entered in this case. This order was entered in the case that my ex instituted, which is the order of protection case. So here I'm putting down she's mentally unstable. Now, this is something that I do not believe I mentioned in my petition. And at the time, I didn't see a need to. I just assumed that the court was going to look at us as two parents and set up a custody and visitation order. When I received the order for protection with all those allegations that I was violent and dangerous, basically I started to realize I needed to tell the court everything. So I'm mentioning she's mentally unstable, and this is probably in reference to the attempted suicide and the time she spent at the Mental Health Institute. She is something repulsed from those she loves closest by paranoia. Okay, what I'm referring to here is the relationship with her close family, so her parents and siblings. I don't want to go too far into detail with that. I don't think that's part of the record, so just a general statement on it should suffice for my viewers, but I know what I'm referring to there. Oh, okay, actually I do put it on the record. I'm saying right here she doesn't speak with her family and they're unaware. They don't even know where she lives. Yeah, that's true. She wouldn't even tell her own family where she lives. My mom and stepmom. Now that is strange. I haven't talked to my stepmom in forever. That's weird. So apparently, I know my mom was in contact with her briefly, but I didn't know my stepmom was. There's nothing wrong with my stepmom. We just didn't really stay, connected after she separated from my dad. So not a bad person at all. Just no communication, no contact. So I'm mentioning here that even my own mom says that she is growing more paranoid. I can't remember this at all. I'm just going to trust my own words here. More paranoid, reactionary, and radical. Attached is a police report. And I'm just underlining that she was uncooperative with the police officers. They had to detain her for the attempted suicide. Now, I've clarified in my previous video that apparently she went, what they state is that she went voluntarily with them to the hospital in the police car. But my perspective at the time was that she refused medical care and that she didn't get in the ambulance, so the police took her in the police car. In the police report itself, it specifically says that she went with them in the police car, which is true, voluntarily to the hospital. So it's a weird, I don't know if that's a normal protocol, but that doesn't sound like it. If anyone else has heard of that before, where the police will take a patient to the hospital because they refuse to go in the ambulance, let me know. It is my concern that she may flee the state in reaction to the notice of this motion. Okay, so I actually did know a little bit about ex partes. For me to insert this sentence here. Now, it's not going to go anywhere. It's just not. You can say this all you want, but without something to back it up, it's just not going to happen, because people are allowed to leave the state with their kids. They are. And as long as it's during their custody time and they're not violating a court order, they're allowed to do that. And as long as they are not abducting the child. And what they mean by child abduction, some people sometimes think that child abduction means leaving the state. It doesn't. If you leave the state, like to go to Disneyland with the intention to return, you know, that's not child abduction. Child abduction is when you leave. You don't even have to leave the state. You could just leave the city and just not, you know, give the kids back in violation of the court's order. If you could even stay in the same city and just hide at another address and not return the children, and you're committing child abduction. So this is something that a lot of people confuse. This comes up all the time in my inbox, and I tell people, I know that you're worried and you're freaking out. I've been there. This video right now is an example of me freaking out. But you can request all you want till you're blue in the face for the court to order them to stay in the state, but they won't do it. There's no basis to, you know, anchor a parent to the state or to a city. Okay, so here I am highlighting the results of the psychiatric examination. You know what? I want to pause here. Some people might say, your ex is crazy, she attempted suicide, she went to a mental institute, all these things are really bad, so the court should have granted your motion. That's still not true. If my ex was so dangerous that she, you know, was going to do something bad to the child based on her mental health issues, then my approach shouldn't have been to keep her in the state anyway. My approach should have been, she shouldn't have him at all in her custody. So I could have used these arguments to say I want temporary primary physical custody and sole legal custody until we can look into her mental health. That would have been a paper that might have been taken more seriously by the court. But when you just try to do something like this, when you try to say that your ex is crazy, unpredictable, unstable, and dangerous, and therefore don't let him leave the state, that's going to make the court say, well, she can't be that bad, because you're basically saying it's okay for her to keep the child as long as she stays in the state. So even for those people who might think that this should have been granted for that other reason, not really. If that was a serious concern, my approach would have been a different approach. And I still think something like that would have failed, because the response from her would have been, hey, I've had the child in my custody 5 months after being released from the mental health institute, and my child is doing just fine. It would have been a lie, but the court would have thought, you know what? The child has been with her for 5 months, so if something would have happened, it would have happened some time ago. So the point I'm trying to make here is these emergency ex parte motions usually don't work. They're usually a reaction by a parent who is freaking out, and as I've mentioned in my previous videos, just don't do it. It erodes your credibility, especially when you're representing yourself, because this type of filing just lumps me in with all of the other self-represented litigants that the court perceives as crazy people. And me getting lumped into that batch of litigant did not help me going forward. It didn't. And it does come to a point where my filings are used against me by my ex's attorney. Basically, I'm filing too many papers, I'm just trying to harass her. I can't remember if this filing specifically was named, but when you're representing yourself, you want to make every shot count. You don't want to carpet bomb the court with a bunch of papers and pleadings, because it's just going to be used against you later on when you actually bring a meritorious pleading. And it's very much in line with the whole cried wolf story. You don't want to be the child who cried wolf when you actually have a serious issue that the court needs to intervene on. Let's continue here. If I was really going to rely on my mom and stepmom's testimony, I would have added one more clarification for the court. I would have stated to the court specifically what my mom and stepmom are going to testify on, and I would have stated to the court specifically that my mom and stepmom will appear in court and testify. This kind of stuff gets filed all the time, and then the judges see the litigants come in and they don't bring any other witnesses. And the litigants think, oh, the judge is just going to believe me. That's why they set a hearing, right? That's not true. When you articulate certain facts in a paper, that is you trying to show that you're entitled to a hearing. And the judge can, on the basis of what you're alleging, give you a hearing. But once you have a hearing, you actually do need those witnesses to come. And if you, let me stop you right there. If there are hearsay exceptions, you might be able to get around that. And I'm not going to explain any more. Instead, what I'm going to do is direct my viewers to the video Hearsay, because some states do have hearsay exceptions with regards to certain types of proceedings, child custody stuff might fall into that category. I know that New Hampshire is one of them, not generally, but with regards to orders of protection. So you might want to look into that video, because you may be in one of those states that has hearsay exceptions that will allow you to provide hearsay evidence to the court that the court can base its decision on. But I don't know what the limits and boundaries are on that, and that would be something for my viewers to research for themselves. Generally, you do have to get those witnesses to come in, and it would make you stand out to the court if you specifically state in writing that you are aware of it and that you are going to provide them. Even better, it would have been not only better, but probably necessary for me to get affidavits from my mother and stepmother. Absolutely necessary and even crucial. When you're trying to make emergency claims, you want to do everything in your power to show the court that you are not messing around. And an affidavit from the mother and stepmother with declarations, or sorry, not declarations, with, well, okay, so either an affidavit that's been notarized or a declaration in lieu of affidavit would have been a huge way to show the court that this is a serious issue and that I intend to not only provide these witnesses, but they have gone ahead and signed lists of allegations under penalty of perjury ahead of time, just to show the court how serious it was. Now, again, I want to take you back to the earlier part of this video where I still don't think that this was a good filing. I regret filing this particular motion, and had I had the experience then that I have now, I know for sure I would not have filed it. But I did want to mention that for some people who may have an issue like this that they think does have merit, and definitely, if you can get affidavits from witnesses, provide them, and make it clear to the court that you intend to bring them to a hearing. So it really comes down to standing apart. You know, imagine all of the hundreds of filings that the courts get from people like me at this time when I don't know what I'm doing. Imagine all the filing, the flood of filings that they get, and wanting to actually get listened to and given an opportunity. And imagine that that is going to work better if you stand apart, if you look different. You don't want to look the same as all the others. You want to go above and beyond and show that you are different, and here's why. I have affidavits, I know I need to bring the witnesses, this and this and this. So I'm deeply concerned that the request of this order, in conjunction with police reports against her, that she will respond by fleeing the state or worse. Okay, so this is an ex parte justification. Anytime you want ex parte relief, you have to explain to the court why providing notice to your opponent would frustrate the purpose of the request. And so I'm satisfying that criteria here, which I wonder where I figured this out from. I don't think I was doing research at the time that I filed this, so maybe it was in the instructions provided with the form. She often only sees her own version of reality. I can't believe that I was cognizant enough to mention this at this point early on. I was always under the impression that I figured this out years later, but here I am in 2008 stating that she often sees her own version of reality. So that jumps out at me as maybe I was more aware of the problem than I really understood I was. Frequently justifies dishonesty and radical actions for some perspective that she sees that no one else does. Okay. In conclusion, this is true. I just am surprised that I knew this back in 2008. In conjunction with this motion, I intend to file another request into the court order, the disclosure of her medical and psychiatric examinations. Okay, yeah, this is going to be in this video too, so we'll hold off on that. Here's a standard boilerplate verification. What I have discussed in prior videos is anytime you're filing a paper or pleading that makes factual allegations, at least my understanding is that anytime this occurs, it is verified later on somewhere down at the bottom, typically bottom or last page of that paper or pleading. It's verified under penalty of perjury, and that's what's going on here. I've made a list of factual allegations in this motion, and so I need to support it with my affidavit. This is required in Nevada. Affidavits are required to support all motions, and when you file pleadings, my understanding is that affidavits are required as well, but in pleadings they're referred to as a verification. Okay, and here's a notary public. So as I've mentioned in previous videos, now in Nevada you can do this by declaration in lieu of affidavit, and it's cheaper, not just with money but also with time, because you don't have to make an extra stop and get a notary to sign it and stamp it. And if you want to learn a little bit more about that, please watch my video on affidavits and declarations. This is the first time I've seen one of these because this is the first time I have filed a motion in the child custody action. I wonder why these aren't included in the order of protection actions. It's interesting. In Nevada, some of our counties require you to attach a additional piece of paper to the back of any filing that basically makes it easier for the clerks to determine whether or not you need to pay a filing fee. And so this is the motion opposition notice. It is only used by the 2nd Judicial District Court. It is not used by any other county. But the other counties do have their own version of it, and it's similar. Like the 8th Judicial District Court has a different form. I think it has a different name, and I think even the fee is different. But I don't know because I litigated in the 8th Judicial District Court very little, and it was only towards the very end of my case. Most of my litigation was in the 2nd Judicial District Court, and this is a form that I constantly had to attach to the back of my papers. And you just go through the step-by-step process here, and you check boxes and stuff, and it just helps you and the clerk determine whether or not they need to charge you a $25 filing fee. This fee is probably higher now, but I don't know because I haven't litigated in the 2nd Judicial District Court for actually, I did do it recently. Not really recently, maybe like a year and a half ago. I guess that's recent to me now, considering the fact that this is back in 2008. A year and a half does sound a lot more recent than that. We'll get more into the specifics as we get further on in the case, but at the time of this filing, it's $25 filing fee. And as I mentioned, other counties don't use this form or use a different form and have different filing fees too. My understanding is that 8th Judicial District Court, which is Clark County, has a much higher filing fee. May be wrong about that, but that's something that I've come across briefly or glazed over. Here's the affirmation. I've talked about this in previous filings as well. Later on, when I would prepare my own papers and pleadings, I would just include the affirmation right above the signature line, and it would just be like a one-line statement, something along the lines of, the undersigned does hereby affirm that this document does not contain the social security number of any person, and that's it. It's better than having an entire extra piece of paper, and all it is we have a statute in Nevada, or at least we used to. I don't know, we may still, we may not. I don't keep up on all this stuff as much as I used to because my child custody action is over, but we either have or had a statute that required anyone who was filing a paper in court to affirm that nothing in that paper had a social security number of another person. It was just to help people protect their privacy. This specific form here is usually one that you would get over the counter if you showed up without the affirmation. And I'm sure that I didn't do that in this case because I was using packets and they would include it in the packet. Okay, so this is the first police report. This is a police report that I covered in my previous video, so I am not going to cover it again. If you want to go into my analysis of the police report on my ex's attempted suicide, please watch part 4 of the My Docket series, and you will see, I go over it comprehensively from beginning to end. And also, you will be able to get a copy of this document down in the description below. Just click on the link and download it. And that way, if you don't even care to go and watch that video and go over my analysis on the police report, you can just read it for yourself. But I don't want to go over it twice because my viewers would probably be very annoyed if I was just covering exhibits and evidence over and over again in my videos repeatedly that I've already covered before. So I covered this, as I mentioned, comprehensively, so I'm not going to do it again. Okay, so we're done with the first filing. So the second is the request for submission of that motion. In this paper, I am basically telling the court that I have completed briefing on a specific issue, and in this case, it's the ex parte motion to prohibit removal of the child from the state. And since I have completed briefing, I am submitting it, the issue itself, I'm submitting that issue to the court for some kind of determination. And as I've mentioned in my video, request for submission, please watch that video if you haven't seen it yet. Not all states or even all counties require this. And in fact, it is my understanding that only the 2nd Judicial District Court in Nevada require this. My understanding is that the other judicial districts in Nevada on their own will monitor their dockets and determine whether or not a decision needs to be made on a particular issue. In second judicial district court, for whatever reason, they want the litigator to tell them, hey, this issue is ready, please look at it. And if you do not do this, the judge won't even look at it. They just won't even have a clue that there is an issue that they need to look at and make a decision on. So if I didn't file this, it would just sit there and never get a decision for months and months, maybe even years. Or if I never figured it out and didn't care, the judge would never make a decision on it ever. So by filing this request for submission, I'm indicating to the court that it's been briefed and please take a look. Now, notice I'm not saying that I am submitting that paper to the court. This is not to submit the motion to the court. This is to submit the issue to the court. Now, it happens to be coincidental that it's an ex parte motion. And because it's an ex parte motion, my ex doesn't have to file any kind of response. And so since my ex isn't going to get notice of this and an opportunity to respond to me, there really is nothing else for anyone to wait on. So upon filing the ex parte motion, I can immediately request for submission. When you do an ordinary motion, the type that you're going to be filing most of the time, if your case is full of ex partes, that's not good, that's weird. An ordinary motion, which is most of my case, which is good, an ordinary motion involves placing your opponent on notice as to what you're trying to do. And that's constitutional. It's under the Fourth Amendment due process. They're entitled to know what you are trying to do to them, unless you're doing an ex parte. And that has all kinds of caveats. Please watch the video Ex Parte Perils to go into detail as to why they are really not a great idea to use, except in the rarest of circumstances. But anyway, if I filed an ordinary motion, I would not file the request for submission yet because it has not been fully briefed. I would give my ex an opportunity to file an opposition. Once she files an opposition, then I would have an opportunity to file a reply. Once I file the reply, then the issue is fully briefed, and then, and only then, do I file the request for submission. And that sends the issue up to the judge. It tells the judge that this issue is ripe for review because it has been fully briefed. Somebody filed a motion, another person opposed it, and then the person who originally filed the motion replied to the opposition. The situation may arise where your opponent does not file an opposition, and in that case, you will file a request for submission on just the motion, but it's crucial that you wait the prescribed amount of time before filing it. Some people will file a request for submission too early, and that's mostly because they don't understand how the computation of time works. If you're a viewer and you haven't seen that video, please watch the video Computation of Time. It's more complicated than it seems. If you file a request for submission without giving them the opportunity to file that opposition, the court will strike it. So make sure you understand how time is computed, and then if your opponent does not respond within that parameter, then you can request for submission on just your motion. And that's because they had an opportunity to respond, but for whatever reason, they chose not to. Let's move on here. Second page, we just have another affirmation. I've already talked about this, so I'm done. Moving on to the third filing. This is the ex parte motion to force her to disclose medical and psychiatric documents. Okay, so I'm not going to rehash everything I said previously, but ex parte, not good. There is no basis at all for me to not provide her notice of what I'm trying to file. There just isn't. I'm trying to get her to disclose medical and psychiatric documents. It's not an emergency, and there's no reason why she shouldn't be given an opportunity to oppose it. Just because my opponent has an opportunity to respond doesn't mean I necessarily am just giving up. I'm just giving her her constitutional right to respond. So by filing an ex parte motion, I'm trying to deprive her of that, and that's not good. So I'm sure that this is denied on the basis that it's ex parte. But again, I don't want to read ahead. We'll find out in my next video, or whenever it does happen to come up chronologically, what the court's response is on this. I wanted to go ahead and add that even if I filed this by motion, what I'm talking about is not ex parte, not emergency. I just used a regular motion and gave her an opportunity to respond. I still think that this would have been denied. And the reason why is because there is a formal process called discovery. In an ordinary civil action, there is a discovery phase. And that is the appropriate time to start digging into these details. So this is, even if it was an ex parte and emergency, this request is premature. So had I had the experience then that I have now, I would not have filed this. I should not have filed this paper. And as I mentioned earlier, it does get denied. I can't recall the basis for it, but it does get denied. Some people might say that I am justified in this request because I could get a temporary order. I don't know if I would call it, I don't know if I would refer to the motion in this way if that's true. As I mentioned earlier, I would instead file some kind of ex parte emergency order or ex parte emergency motion for a temporary custody and visitation. And then at that point in time, I would probably mention in the motion that there are psychiatric or mental health issues. And I would probably place in the motion that if my opponent is going to refute this on a temporary basis, please bring all of your mental health records from that that incident regarding the attempted suicide and all that. Yeah, so even if you think that this is valid because she has mental health issues and it's a concern, the way I went about it is still wrong. It would have been more appropriate to say I want temporary custody for these reasons. Let's see here. Okay, West Hills Mental Institute, she was detained for 3 days. So I'm asking for her to produce these documents. And then, of course, these are the same mistakes that I made in the previous motion with the date and the reference to this order. Okay, it looks like I reiterate the first paragraph of the other motion. Yeah, it looks like it's reiterated verbatim. So far, it is still reiterated. It is my concern that she may have, what does this say here? Chemical imbalances implying a schizophrenic pattern of behavior. Okay, I'm laughing because I talk about this in my video, evaluating mental health. Please watch my video, evaluating mental health. I do not recommend taking this approach, and the reason why is it seems to me, having represented myself for all these years and seen other people's cases, it seems to me that it is much more likely that you will be successful if you focus on the manifestations of abuse and neglect that stem from whatever mental health issue your opponent has. If you try to focus too much on the labels, you really corner yourself into having to provide an expert. And I also mentioned in the video evaluating mental health that I didn't know what she had early on. I thought she may have had antisocial personality disorder, and I'm sure that other things popped up. But what happens is when you make these allegations, you just get lumped into all the other crazy people that make these allegations. And so the court just assumes you're one of those other people that doesn't know what you're talking about. And so it's better to not go for these labels and instead bring up the things that their mental health issues may be causing them to do. And that's how I ended up winning later on when I finally realized this. I got a modification of custody because she wasn't taking our son to school. She was neglecting him dentally. She was forcing us to exchange at midnight. And so instead of focusing on the labels of whatever mental health issues your ex might have, focus on what their mental health issues are causing them to do. The actual abuse or neglect that is occurring is something that you can prove yourself without an expert and without labels. Whenever you use these labels, it just makes you look like one of the other crazy parents who doesn't know what they're doing, who's filing a whole bunch of papers in court. You're not going to be taken seriously at all. And so this specific line here, I would definitely not have, I would have definitely excluded it. I might have stated something like, there may be some kind of diagnosis that this court needs to look into, but I wouldn't have suggested one. Well, luckily I follow it up here with, I hope that I'm incorrect. But if these indications are true, I intend to follow the motion up with an ex parte motion for temporary custody. Yeah, if I was going to do anything, this would have been the first motion. I'm concerned by her current erratic behavior. She may harm the child. She's lamented before about drowning our son in her dreams. I can't even remember that. It's possible. That's scary. That's really scary. That scares me right now as I read it. Yeah, maybe I would have filed that motion for a temporary order, for a temporary child custody and visitation order. If I had known what I was doing, that's what I would have filed. And then I would have specifically stated that certain witnesses will appear and that we need to review the psychiatric documents. The first reports from West Hills indicated post-traumatic stress disorder, but her reactions towards her closest loved ones and family have indicated patterns of schizo. If the records of West Hills indicate comprehensive imbalances towards a disorder, I intend to follow up with emotion for... So, you know, maybe what I was doing was trying to be nice. What I was trying to do was take it step by step. First, give me the records, and if they are really dangerous or they indicate some kind of a serious issue with regards to her ability to parent a child, then I will file some kind of motion. But in reality, that was the wrong approach. Going back in time, I wouldn't have done it that way. I would have filed an ex parte motion for temporary custody and visitation. I would have included affidavits from witnesses, my parents. I would have included a demand for the court to look into the mental and psychiatric records. That would have been the better approach, and I might have gotten somewhere had I done that. And I wouldn't have done it on a self-help form. I would have done it custom. I fear that if the other party is contacted and she knows what her medical reports indicate, that she may flee the state or worse. So it really just goes to show you how important it is to put these papers together in the way that the court understands, because I don't know, I mean, maybe if I was a judge and I saw something like this, I might have been more proactive and I might have disregarded the requests that the litigant was making and instead entered some kind of temporary order demanding to see the documents in secret or something like that, review them, and then determine if there was going to be anything that I wanted to do as a judge. But most of the judges won't do any of that. It's a lot of extra work. They'll just say, oh, well, he doesn't follow the criteria of the law, so I'm just going to deny it. Just summarily deny and get rid of you. Typically, that's the attitude of most judges. So, I mean, some people might say the judge should know better. The judge should be wiser. He's 3 times your age. He should construe your request in a way that the law understands, and he should take active steps to protect the child, even if you don't know what you're doing. It's not fair for a child to suffer harm just because a litigant is representing himself and is ignorant. But in reality, this is not what the judges do. Most of them just try to get rid of you and will deny your request. At least in 2nd Judicial District Court, they'll just summarily deny your request. In 8th Judicial District Court, you get hearings all the time just for anything that you file. So it's possible that by filing this paper, even though it's not the best way as to have conveyed my intent, it's possible that that hearing that I would have gotten might have caused the judge to inquire further. I'm still skeptical, though. I really am, especially when I don't have an attorney. And later on, my ex, in fact, very soon, my ex will have an attorney. Very, very soon that's going to be happening. And when you don't have one and they do, typically it's lopsided contest, because the judge will, at least from what I have seen, the judge will give a lot of deference to the attorney. And that's just because they have a relationship with that attorney and they don't know who you are. You're a complete stranger to the judge. You're just a random litigant in their courtroom who's going to be gone, and they'll probably never see you again. Already covered this motion opposition notice. Already covered this affirmation. This looks like the attempted suicide. Yeah, so I'm not going to cover this again. Yeah, that's everything. Moving on. And we have the request for submission for that ex parte motion, the one to disclose medical and psychiatric documents. I already covered how this works, so I'll move on. And I already covered this affirmation, so I'll move on. And here is a summons that was filed way later, and I'm sure that's my fault. And here we have, it's just a filled out summons. In part 1, I provided a blank one to the viewers just so you would know what it looked like. I know it was issued at the time that I filed the petition, but just because it was issued doesn't mean it's ready for filing, because it needs to be served to the defendant or the respondent. And so once it was served, yeah, here we go. Here's the affidavit of personal service. This Kelly Aboites person, I remember her. We were co-workers at Circuit City, and I had tried to get help from other process servers, my friend Mike. And as I mentioned in my first video, it was very difficult to serve her. So it looks like, and I can vaguely recall this, it looks like Kelly was the one who was able to serve her. And it specifically mentions that I served the petition, the personal case information sheet, the financial declaration, and the civil family related cover sheet to her. Yeah, and it was served September 3rd. So I probably got a call or something from the court wondering if I had served her on time or not, because this was filed way later than September 3rd. Let's roll this up. Yeah, September 22nd. I should have filed it on the 4th or the 5th. You know, waited almost 3 weeks to file it. No big deal. I mean, it could have confused the court. They may have thought that I hadn't served her yet, and they might have vacated hearings. So, and here we have the affirmation again. I already covered this. Going into the aftermath, you will see that nothing has changed. Both of the motions that I filed were filed for free, and the details as to why are in the motion opposition notice, which I covered briefly in this video. The gist of it is that no final determination has been made on the case yet, and that is something, this specific form, this motion opposition notice, is something that I'm going to be going over quite often in the series. It gets a little bit more complicated later on after the court, you know, enters judgments and decisions, orders, stuff like that. But at this point, it's pretty clear that you don't get past checkbox number 2 because no orders have been entered yet in the case. So for that reason, I didn't have to pay a filing fee. Of course, this form isn't the end-all be-all. It's built based on a statutory scheme that the legislature enacted that determines whether or not filing fees need to be paid in these types of situations. And so they provide these to the litigants and, of course, the clerks so that they can review it very easily without having to kind of scratch their heads and look into your case. They just kind of trust you. I wondered always, or not always, but sometimes I wondered what would happen if a litigant filled it out deceptively just to avoid paying filing fee. I don't know. It's possible that something like that could happen because I really don't think the clerks check up on people. I think they just look at it and read the check boxes and say, okay, it's free, or okay, pay 25 bucks. I suppose the fact that it's only $25 probably helps a lot with respect to whether or not anyone wants to game the process. And I suppose at this point I'm going to go ahead and end this video. If anyone has any questions, definitely post them down in the comments below, and I will see you guys next time.